Do you know what you own in business, or are you letting your assets walk out the door without capturing the value for them? This is Sharon from HD BizLaw, and let's answer that question. So in order to know what you own, you need to know what your digital assets are. It's important because so much of the world now, so much of business happens digitally. And when I talk about digital assets, I'm talking about, of course, things like your accounts, your passwords, and your domain names, but I'm also talking about the tools and techniques and methods that you have developed to perform the services or do the business that you do. For example, a code bank, a software app, an algorithm, a spreadsheet that you've done macros for, an analytical method that you've created into a tool that you use over and over when you perform services for your clients. All of these things are called digital assets, and they are very important and very valuable to your business, even if you aren't thinking about them. So how do you know what you have? The first thing that you do is actually do an audit, a self-assessment of your assets. Whether you write them down on paper, put them in an Excel spreadsheet, or put them in a workbook, and I have a workbook that's available, you need to figure out everything that you have so you can make sure that you know what you own and actually are protecting them. And as part of knowing what you own, you need to make sure that you own everything you think you own. So you need to do the audit, the self-assessment, make that list of everything that you can think of. Trade names, domain names, designs, software, spreadsheets, reports, all of it. Then in the next column, figure out, did you create it yourself or did someone help you create it? If you created it yourself, under copyright law, you own it as the author. You instantly became the copyright holder the moment you put pen to paper or typed it into your computer. You own it without doing anything else. But if somebody helped you, whether they did it for free because they were a friend, they did it and you just gave them some money, if you did not have a contract with this person who created whatever it was for you, and if they were not your legal employee under the you pay their taxes definition, you don't own what they did, they do. So it's important to know what you own and what somebody else might have ownership in. Because you don't want them coming back later when, let's say they helped you create an app, becomes really, really famous, and they come back and go, pay me or give me more because they figured out that they own a key part of the app and not you. So if you figured out that somebody else owns your digital assets and not you, we need to remedy that, and it's okay. We can. For things that are copyrightable, reports, drawings, software, we can go back and get an assignment later. And believe me, it's cheaper to get it from somebody now before whatever you're doing becomes famous or more valuable than later. So you figured out what you own, you figured out whether or not you own it or not. And now we want to protect it. And the way you do it is, as I mentioned, you instantly in the eyes of the law are the copyright owner. But in this world, which is so online, people forget that just because they can find something on the internet or in public, it doesn't mean that they get to use it for free. So how do we let people know that this is yours and you don't want them using it? With a notice, specifically a copyright notice. And a copyright notice is free to use and you get to use it without doing anything else. So on every page of every document, report, drawing, in the footer or in code in software apps, you want to put a copyright notice, which is super simple. It's that C in a circle symbol, the year, and your name or your business name, period. That's it. With that magic little phrase, you have put the world on notice that you are announcing to the world that this is yours, you know it's yours, and no, they really shouldn't be using it. And if at some point somebody does use it, the fact that you have that notice everywhere, it makes it much easier to request from either a social media vendor such as Instagram or Facebook or TikTok that you want them to take down this person who is infringing your copyright, or if for whatever reason you wanted to take legal action against them or write a cease and desist letter, you can say, look, the copyright notice was right there. And not only is it on this, it's on everything I do. And you'll see at the end of all my videos, there's a copyright. It's because I don't want somebody copying my video. So what can you do now that you know what you own, you've protected it with a copyright notice, and we've made sure that you in fact own it? What's something else you can do? If you've got something that's particularly valuable or a secret, it's not something you're going to give to a client. It's something maybe you'll show a client, or that you're going to do it in a very limited circumstance, but they don't get to keep it. Or it's information that you are working on and you haven't filed a patent on it yet, or it hasn't gone public yet, but you need to talk to somebody about it. What do? You want to put on not only a copyright notice, but a confidentiality notice. A confidentiality notice is also free to use, and it's very simple. Confidential information of you or your company. And again, footer or header of every page of everything that you're going to show. And you might even put it in red or bold or italics. You want to make it clear that this is not only your copyright information, but your confidential information, which this notice serves as a reminder that somebody shouldn't disclose it further. But you also want to go probably one step further. If you're going to disclose your confidential information to somebody because you're going to have a discussion to evaluate maybe working together, you want to have a non-disclosure, or also known as a confidentiality agreement, between the two of you that says they will not use your confidential information. It isn't enough, if it's really valuable, just to have the confidentiality notice. You really want to lock somebody up legally to make sure that they cannot use your confidential information either for themselves or give it to a third party. And this comes up often when there are client pitches. A client sometimes has bad intentions, and they'll get pitches from lots of consultants in order to get the ideas and use them. A consultant who doesn't know better will just go into a meeting, tell them all the ideas, and have no restrictions, and then that potential client never becomes an actual client because they've gone off and used it. But the person who knows better, the consultant who knows better, has a confidentiality agreement with the client that says, I'm only showing you this for the purpose of you deciding if you want to work with me. And with an agreement that it's going to be a little longer than that sentence, it then prevents that potential client from stealing your work and not hiring you. Or worst case, if they do, you can go after them. And that's not the only contract that you want to have to protect your digital assets. You heard me mention that if it turns out that somebody else helped you, but didn't actually assign you the rights to a copyrightable work, you can fix it. And we fix it through something called a nunc pro tunc assignment. Very lawyerly, I know, Latin, basically means for what it was. We can retroactively get the rights. It might cost you $10 or $100, but if there's something that's worth thousands, it's absolutely worth it to make sure that you have the rights. You also want to make sure that if somebody's going to be helping you in the future, they help you under a contract that assigns the rights from them to you. And if in fact you're working with a client, you want to make sure that your client contract doesn't assign away your existing digital assets that you use from client to client to client. And a lot of agreements, consulting agreements, if they're written by the client and not by you, are actually going to put you in the opposite position. The client's going to try to do a land grab for everything that you do for them or everything you even give to them. And if you've included any of your pre-existing tools, you won't own them anymore. They will, and you won't be able to use them again. So you want to make sure that you're protecting your digital assets by having solid contracts that protect you, both when you need to get the rights, but also when you want to protect against giving away too many. So let's make sure that you know what you own so you can protect what you own and keep what you own. This is Sharon from HT Biz Law. Stay safe out there.